Hello, everyone. I would like to welcome you to our webinar today on using the family violence definition in your family law case, which is hosted by METRAC Action on Violence with guest speaker, family lawyer Kerry Guerin. Please note that this webinar will be recorded and reflects developments in the law before October 21st, 2021. The recording of the webinar will also be available on our FLU website at onefamilylaw.ca in about a week or two. My name is Andrea Collins Fitzpatrick. I am the Legal Director for METRAC's Community Justice Program. I would like to begin with a land acknowledgement. We acknowledge that this land is the traditional territory of many nations, including the Huron-Wendat, Haudenosaunee, and the Mississaugas of the Credit. Today, the meeting place of Toronto is still home to many Indigenous people. We honor all the First Nation, Métis, and Inuit people living on this land. We recognize the traditional territories on which our organization is located and on which our programs and trainings take place. Before I move to our presenter today, I would like to tell you a bit about METRAC. METRAC works to end gender-based violence across communities through education, research, and policies. We have been in existence since 1984, and our programs are devoted to advancing safety, justice, and equity. METRAC's Community Justice Program provides legal education and information related to gender-based violence. Through our Access to Justice program, we provide legal information in areas of family law, immigration law, criminal law, employment law, and human rights law. This webinar is part of a Family Law Education for Women, FLU, series. FLU's resources are available in 12 languages, ASL videos, and accessible formats. You can visit our website at onefamilylaw.ca for more information on your family law matters. I would like to remind you that we will have a Q&A after the presentation. If you have any questions, please post them in the chat. We also have a survey that we would please like you to fill out, and it will be posted in the chat towards the end of the presentation. Before I introduce our presenter, Kerry, today, I would also like to thank Kenny Ann, our Justice Program Coordinator, for running the PowerPoint presentation today, and our technician, Ferdinand. I'm delighted today to have Kerry Guerin to speak to us about using the family violence definition in your family law case, and I thank you all for joining us today. I would now like to introduce Kerry Guerin. Kerry says she often gets asked, why is lawyer calling? She says that ever since she can remember, she would protest unfairness. As a young girl, she stood up to the bullies who harassed her schoolmates, and now stands up to bullies at court. From age 3, in Kerry's family, everyone was expected to, quote unquote, take a position on a political topic and, quote unquote, back it up at the dinner table. She is grateful for those dinner table training sessions. As an adult, after seeing the bad deals many victims of violence were getting at court, even at the hands of violent exes, she felt compelled to create a group called Abused Women's Advocate. The dedicated volunteers at Abused Women's Advocate were community workers, social workers, public health nurses, lawyers, and Kerry. They supervised child access exchanges, provided victim witness support, legal liaison with police and Crown attorneys, and found community resources. Kerry also helped mothers create family law action plans. She brought this holistic approach into her family law practice when she took her call to the bar in 2000. Kerry remembers the amazing feeling she had her first year of law school when she walked into Osgood's legal clinic and saw her phone number on the wall for Abused Women's Advocate. Today, Kerry's motto remains focused on supporting victims of violence as an Ontario-wide Children's First family lawyer. I would like to provide a disclaimer today by reminding you that this webinar is for general information purposes only and is not legal advice. The legal information provided is not intended to be used as legal advice for a specific legal problem. Please always check with your family lawyer to ensure whether any tips you wish to try would apply to your case. The topics we will be covering today are background on the new definition of family violence that was introduced in the Divorce Act and the Children's Law Reform Act earlier this year, the definition that was introduced earlier this year, the duty of parties in family law cases to include any information on family violence in court documents, the duty of the court to consider family violence, and how to use the definitions of family violence in your family law case, including the types of evidence that will be required. We recognize that information in this webinar can be difficult and may bring up overwhelming emotions. If you're feeling upset by anything in this discussion, we encourage you to stay grounded and to practice self-care. Before I hand over to Kerry, I would like to give you a brief background on the recent amendments to the Divorce Act and the Children's Law Reform Act. So prior to March 2021, there was no formal definition of family violence in either the Divorce Act or the Children's Law Reform Act. So both were recently amended as of March 1st, even though this has been in process for many years, to include that definition. One of the purposes of the new law is to consider family violence in family law cases and to make sure that where those cases involve children, that suitable parenting arrangements are made. So today we will be talking about family violence in family law cases, about separation, divorce, and parenting orders under both the Divorce Act and the Children's Law Reform Act. We've also included a bit of information about Section 16 of the Divorce Act, as this tells us about some of the factors that the court will consider when they're talking about family violence or when they're examining whether there has been family violence in a particular case involving children. There are many factors, and I'm not going to go through all of them, but I will say that in making orders about decision-making responsibility, which used to be, and parenting time, which used to be called custody and access, and contact, which is the amount of time that the court will order for a child to spend with someone who's not their parent, the court has to consider any family violence specifically relating to the impact on the ability of the parent to meet the needs of the child, and whether it's appropriate to make an order that would require cooperation on issues affecting the child. So I'll now move on to the definition of family violence that is in the Divorce Act and the Children's Law Reform Act. The definition that is on the screen says, family violence means any conduct, whether or not the conduct constitutes a criminal offense, by a family member towards another family member that is violent or threatening, or that constitutes a pattern of coercive and controlling behavior, or that causes other family members to fear for their own safety or for that of another person. And in the case of a child, the direct or indirect exposure to such conduct. The court will consider all these factors in making a decision involving children in a family law case. This is obviously not a non-exhaustive list of the factors that the court will consider. I will now hand you over to Kerry, who will give us detailed information on how evidence of family violence will be presented in court and the kinds of evidence that would be helpful to present. I'll now hand you over to Kerry. Thank you.
Thank you, Andrea. And I think you give me too much credit that I'm going to be that expansive in my explanation, but I do want to share my experiences. That's how I like to approach it. And I also want to reassure people what I'm going to do before I go over the list that the Divorce Act provides for the judges to consider. I want to reassure and encourage everyone, and when I say you, I mean you or the people you are providing service to or supporting in your role, whether professionally or as a friend, family member. I want to reassure and encourage you to tell your lawyer about all forms of abuse. And I say that even if you are not fearful, and even if it is not an apparent safety issue. Excuse me, that's in the definition. But I'll tell you why it's important to tell about all forms of abuse, not only if there's excuse me, it's dry here, not only about safety issues. Many family court judges take all forms of abuse seriously, and they want the information. Some judges understand that victims might not feel fear, even though there is a big risk to them. And there are factors that may not clearly involve safety, but they may be risk factors. I'll give a quick 2 examples. Disinterest in a child could be a risk factor, and boundary pushers, people who push boundaries, don't accept you setting boundaries, even if they do it in a friendly way, that might be another risk factor. So I like how Andrea said earlier, the list is not exhaustive, and also it's any other relevant issues. So now I'll go on first to list what a family violence definition includes, and then I'll backtrack and I'll go over each issue, as you can see on the screen, and just give a few examples of how to approach it. I'll also explain a bit about the court's responsibility and the responsibility of participants, whether the person is a victim of violence or has serious concerns, or even the person who is abusive have obligations to the court as well. So the first one is first thing I want to say is the definition includes the examples on slide 14. It's not limited, and that's good that it's worded that way. And if children are exposed to violent acts, they will be considered to have experienced family violence. Family violence is not necessarily a criminal offense, although some of the things listed there are criminal code offenses. And it's not required to be a criminal offense to be considered family violence when we're dealing with a family court. Now, we all have a duty to report. And when you come to family court, if you've suffered family violence by another family member, or someone, a child has, or someone in your household, you have a duty to report that. Especially important, well, this is essential actually, where children may be exposed to that person. You must tell your lawyer if you're afraid of your ex-partner or someone who associates with them poses a risk of harming or harassing you, children in your care, or other household family members. So it might even be someone who just visits your ex, doesn't even live there, but they are there when your children are there. And if they pose a risk, you must report this. Duties in a family law case. The judge must consider family violence. This is a mandatory requirement, and you can see in a form, and we have the link there, section 35.1 court form, where the judge is obliged to consider family violence. That form asks a number of really relevant questions to help the judge understand your situation. And that includes at page 3, paragraph 8, when the court is assessing a person's ability to act as a parent, and Andrea made reference to this, section 16 of the Divorce Act and 24.4 of the Children's Law Reform Act require the judge to consider whether the person has at any time committed violence or abuse against his or her spouse, the parent of the child to whom the parenting claim relates, a member of the person's household, or any child. So that's where the past matters. Some people are mistakenly told, well, past abuse, just brush it under the rug or don't sweep it under the rug. That's not true. The past informs the future. So again, talking about the duties of the court has to consider the family violence and how it impacts that parent's ability to meet the needs of the child. And when you see the list, you'll understand better how important that is. Whether it's appropriate to make an order that requires cooperation between the parents, and other considerations. Now, how can a judge fulfill their duty? Well, on the 35.1 form, you as a participant will have to acknowledge, I'm aware of the following violence or abuse that the court should consider. And you need to describe the incidents or episodes and provide information about the nature of the violence or abuse, who committed it, and who the victims were. I would also add, obviously, the timeline, not to discount past abuse, but just to inform the judge. Also on the form, 35.1, at page 6, paragraph 13, again, you must make a commitment to the court. You acknowledge that the court needs to be updated if there's any changes that are relevant to this issue, and also if you discover that your affidavit was incorrect or incomplete. And that can happen. Maybe you saw different drafts of the affidavit and you later see that your lawyer provided the wrong one that was incomplete. Then you can either provide an updated 35.1 document, because you'd have a duty to serve that. Or if there's a minor change, just a simple affidavit might be enough to correct that. And then we're on to the slide 23, defying the he said, she said myths, or they said myths. He said, she said, she said. First, don't let someone silence you with that phrase. It's used to silence people. Secondly, your statement, your affidavit that's sworn, or your sworn testimony, it is evidence. And the details you provide can help a judge decide. This is really key. So many times I've heard women say, well, I've been told that it's just my statement or just my word against his word. Well, you're in family court, and other courts, just because it's your word doesn't mean anything. You're a witness. Whatever you are a witness to is valid evidence. Gathering your evidence. Now, a lot of women don't know that people around them have witnessed things that they may not be aware of. So gather your witness statements as early as possible is what I say. It's really important. People move, people change their minds, people get fearful or confused and conflicted. So getting the statements early is good. So some examples of what might show physical or prove physical violence is police reports, convictions, medical records, evidence of family violence from other family law or civil court cases, witnesses. And it's important to note that physical violence includes forced confinement, but it does not include defending yourself or another person. So the forced confinement issue is one that I see arise a lot, where a lot of people don't realize if someone's blocking your way to somewhere you're entitled to go, that's an assault, actually. It's a criminal code assault now. Whether you can prove it in criminal court is a different issue, but don't be shy to mention these things. And it is good to speak not only necessarily with a family lawyer, but definitely with a family lawyer, the details of any such incidents. Because some people have felt that they were in the wrong. They may have pushed the abuser. Their abuser has a history of violence. They push, and they may not have thought back to what happened just before you pushed them. Were they blocking you? Were they blocking your exit? That's an assault. You can defend yourself. So all those considerations must come into play. Next is is listed as sexual abuse, another form of family violence. And many times people feel embarrassed and ashamed, not because they've done anything wrong, but they feel ashamed to say, I was with somebody who was sexually abusive, either to themselves or to a child or another person. When it comes to children, interviews of an abused child are really essential. It's ideal to have the first interview done by a skillful interviewer. And there's a big gap in that service. We need many more skillful interviewers who understand how to interview children without leading them. The other thing is follow-up counseling for children. It's important for the well-being, and also it's normal for children to open up to only one person they trust. It doesn't always happen that way, but sometimes it does, and sometimes it takes years for a child to open up. It's good for them to have that access to somebody reliable they can trust. The next issue they list is C, threats. So family violence of threatening to, kill or harm somebody. Some threats are obvious, and some are not so obvious to outsiders. They may have specific personal or cultural meaning. So explain in detail why you feel threatened, why you know the other person would understand it as a threat, the person who's making the threat. And in some cases, a cultural expert might be helpful as a witness. This is true, especially when you're having things interpreted or translated. So what the cultural meaning of that phrase is. And the next issue family violence includes in the list is D, harassment, including stalking. Now, harassment, again, some harassment doesn't invoke fear. Some harassment may be a boundary pusher who continually comes to your workplace or your home. They may even do it in a friendly way. So be aware, be open, and tell your lawyer all about the details that seem disturbing or concerning. Excuse me. Some of the evidence may include copies of restraining orders. Keep copies of phone calls, texts, voicemails, DMs, direct messaging. Reach out to potential witnesses. Again, searching court records and social media. Follow-up may help. I'd like to point out some of the apps for communication. People can delete their message right away. So if you're dealing with someone you know is an abuser or you suspect is in the family law context or any other, frankly, don't use those apps. Family violence includes also we've gone to E, the failure to provide the necessities of life. Now, we've also have listed here further on financial abuse. So they are distinguishing the difference between a failure to provide necessities of life and financial abuse. So that's important. It's some evidence might be having doctors measure your child's development and photos that show the parent may not have been caring for a child properly and may not show, or it might, on the other hand, show that the child has medical issues that are interfering with them thriving. For example, if you're accused of not providing for your child's not doing well, you want to definitely see doctors, get specialists involved, if in fact that's not true, and you're doing everything possible. It may, I would say it's most likely relevant if the person has failed to provide the necessities of life for another child in the past. And what evidence you have on that is the same as other methods of gathering evidence. You might go through court files, you might already know someone they were involved with before, checking social media, etc., or Googling, frankly. It doesn't mean that's evidence, but that may lead to witnesses who are able to provide evidence. Sometimes it's evidence. So psychological harm, that's a very broad definition, and I'm glad they included that because many things are harmful to a person emotionally, and that can have a real impact on your health. A lot of times people who are used to being abused have not recognized that people around them may have witnessed this emotional abuse, this psychological abuse and harm. So it's important, again, to have your lawyer or a private investigator interview your witnesses. Many times people have opened up to me, the witnesses have opened up to me much more than they would to their friend or family member. They may feel that if they talk to their friend or family about the verbal abuse or even physical abuse they've witnessed, that the victim would feel that they're nosy or interfering, or that the person would feel ashamed. So it's really important to open up and reach out to witnesses. Many times we found corroborating witnesses who have witnessed things my client had no idea there was direct witnesses to. Now, as we were talking about financial issues before, financial abuse. So evidence may include examples, taking your money, doling out an allowance, both look at your bank records and seek the other person's bank records. That may show indications of financial abuse. For example, you may be putting all your checks into the account, but you don't get to access the money. And the other person might be spending it frivolously or hiding it, sending it to other accounts and keeping it from you. A disparity in who has sufficient funds to control, that might also be another example of financial abuse. Excuse me. Another one I'd like to address that may or may not address safety is child support payments. So many of our family court judges take non-payment of child support very seriously. And it's good that they've listed financial abuse. I have used an article by Justice Spence of one of our Ontario courts, in trials even, and the title of his article was called Child Support, Whose Right Is It Anyway? Well, the answer was, it's the child's right. So that's an example of how some judges take this very seriously, and they don't minimize financial abuse. I'm not saying all judges will understand these issues, but it is our job, both as participants and as lawyers, to help them understand, and provide the evidence that can help them make a decision. Now we go afterwards to H&I. Family violence is also including threats to kill or harm an animal or damage property, and also actually killing or harming an animal or damaging property. I mean, logic, common sense tells us people will experience this as a clear threat to anyone who defies the abuser. I mean, that's just logical. Now, if some people don't perceive it, that in and of itself doesn't mean it should not be included in the materials. Fortunately, it's required that you provide this information. That opens up the door for women to not minimize what's happened to them and to not allow, for example, their lawyer or other people tell them, well, that's not really something the judge should consider. Yes, it is. It's in writing. Thank you very much. You're required to provide this information. So some of the evidence may be, again, people who may have visited your home. Your child may have spoken to someone at school, a child or another adult, who didn't know what to do when they heard these stories. And also, if you have pets and they've been brought to the veterinarian, they may have noticed the harm. They may have noticed abuse. So I would say there's usually a way to prove things, not in addition to your own statements. There's often paper evidence and other forms of evidence. So we'll recap, and there'll be opportunity for questions as well, but we'll recap on gathering evidence. So remember, overall, the evidence you provide helps a judge decide. Judges don't have a crystal ball. They need to know this information. So tips: 1, your sworn statement is evidence, and that includes sworn testimony. 2, valid witness statements include people who are close to you, such as family and friends. I have heard people tell me that they were told, family and friends, they can't use their statements, they'll be biased. Well, maybe they're biased, but that doesn't mean they're not telling the truth. Number 3, best to use a private investigator, PI, or your lawyer to gather witness statements. I'll tell you why briefly. I find that when clients ask for a letter or a statement from their friends or family, their friends or family are, first of all, not waxing poetic in as much detail about their friend, because their friend is probably modest and can say, well, I'm not that great. I'm not so fantastic. I'm not the best parent. But actually, their friends and family may think they are. And secondly, they may be shy to tell their friend, I saw him do this to you. I saw her do this to you. But with me, there's an opportunity to open up and tell more. And I have often gathered information about eyewitness accounts that my client did not know about because I spoke with the witnesses. And other times, we've sent a private investigator, not only to friends and family, sometimes to neighbors of the abuser who know about other abuse or other criminal activity. And you choose the right PI, they may go in and people may feel more comfortable opening up to them. Number 4, be specific in your description of any form of abuse. So many legal documents I've seen say things like, I was physically, emotionally, and financially abused by the other party. And then they give no details. That is not acceptable. Number 5, so we're on to the next one, tip, I would say. Keep a complete copy of all forms of communication the abuser has made towards you. 6, acquire copies of any documents that may support your experiences. Police records, medical records, banking records, social media, court records. I'd like to point out a police report, it may even redact the other person's name or information. I get that. And just because someone is found either not guilty or the case is dismissed or it doesn't proceed to trial, even if you're not taken seriously, it's still evidence. And by the way, you could send information to update police notes and records. So number 7, evidence of other people's experiencing abuse by the same person and or experiencing abuse by their close acquaintances may be relevant. And that goes back to the issue of not only the abuser who you're in family court against, but if someone close to them is abusive and poses a risk to your children or child because they're spending time with them, evidence about their abusive behavior. And I would like to add, actually, abusive behavior could include increasing a risk. So that's not under this category exactly. So this is another reason why any other relevant evidence. So it could be that the abuser engages in criminal activities that increase a risk of harm to them. So what's going to happen to your children if they're hanging out with them and someone assaults them? So let's say an example is a drug dealer. There was a drug dealer years ago. He owed a debt, and instead of him being assaulted, the perpetrator shot his child. Okay, so that's an example, but it's a very extreme example, but it's an example. So again, I want to assure everyone, please don't hold back any of your concerns to your family lawyer. And it's clear, thank you all for being here. It's clear that you all care deeply about family safety and family well-being. That's why you're here. And thank you also to METRAC for inviting me, because it's always an honor to team up with METRAC and share information and hear from everyone here. Thanks again.